Thank you, Kyle. Good afternoon. My name is Veronica Vecchio, as Kyle stated, the section chair for employment law. And I'd like to introduce today Mr. Gregory Cairns, who's special counsel at Aiden, Serta and Associates, LLC. Mr. Cairns has over 40 years of experience as an attorney in matters relating to workers' compensation and employment law. He is the founder and principal instructor for the Center for Workers' Compensation Training. And in 2010, he received the Lance Butler Award for service in the Colorado workers' compensation community and has served as president of professionals in workers' compensation. We appreciate his time here today educating us on workers' compensation law. Thank you very much, Mr. Cairns.
Thank you, Veronica, and thank you, Kyle, and thank you, Boulder Bar Association, the Employment Lawyers section, for having me talk about workers' compensation. Let me preface my remarks by saying that in 1991, a union leader on the eve of some major reforms described the Colorado workers' compensation system as follows: a Byzantine system only partially understood by those who work in it every day. Well, I've been working in it every day for 40 years, as was stated, and I can tell you I don't know everything, but I've learned some things. I've seen patterns, and I want to share them with you today in this brief hour together. If you have questions, you can unmute yourself, or you can put them in the comments section. I'm also available after this seminar at any time at 303-248-6548. I am with the firm of Aiden, Serta and Associates. We are a firm in Denver, Colorado. We do practicing workers' compensation throughout the state of Colorado with a special emphasis on serving the Latino population. Staff here is bilingual, with the exception of my paralegal, Andrea Lauer, who's listening in probably, and myself, but we have fine interpreters to help us at all moments in time. Colorado workers' compensation, you should see on your screen a PowerPoint that I prepared a good 6-7 years ago for a management group that was actually employers and management representatives from employers. And I thought that outline might be as apt today as it was back then, because employment attorneys need to know the same things that the people they serve do, whether you serve employees as a claim attorney or whether you serve management as a defense attorney or insurance company. You still need to know the same principles. So I'm going to go through those using this seminar. Admittedly, it's old. By the way, with respect to materials that Kyle referenced, I do have a chapter from the Senior Law Handbook. It's called Chapter 10, Workers' Compensation and Seniors, that we're going to share with you. It is out of date by 2 or 3 years, and for you to update it, you need access to a publication that the Division of Workers' Compensation through Craig Ely has put out to update it. So be mindful that some of the information with respect to statutory maximums and with respect to number of days to report injuries and these sorts of things have been updated. And as you know, as attorneys, your authorities are only as good as they are updated and correct and accurate. All right, so let's see if I can advance this slide now. Here's 12 things safety managers or you employment attorneys need to know about Colorado workers' compensation from a guy who's been doing it 40 years. Yeah, 40 years. I started September 1 at Holland and Hart, and a year later I was handed my first workers' compensation case, and I spun out of there after 2 years, and I've been doing it nonstop ever since. I've represented employers for nearly 40 years, insurance companies, self-insured employers, but 12 years ago I also started to do claimant work, and therefore I have the perspective of both sides of the practice that I'm going to share with you. First of all, number one, it's a no-fault system. You probably know this. Workers' compensation is an exclusive remedy because, unsafe, silly, stupid employees who get injured still basically get workers' compensation benefits. It's a no-fault system. But the trade-off they get for that is they give up their right to sue the employer for negligence, for having an unsafe workplace. It's a trade-off that's been there since workers' compensation in Colorado was started probably over a century ago, and it's a trade-off we're going to see in the near future. You can't sue your employer in the state of Colorado for having an unsafe workplace. By the way, everybody in Colorado has to have workers' compensation insurance if you have at least one employee. And by the way, you can insure yourself if you are self-employed. I myself make sure that I have a workers' compensation policy. It's one of the best omnibus policies you can get. There are a lot of brokers that'll get it for you. Why not have it? It will give you the benefits we're going to describe in just a few minutes if you are injured. And you know what? Auto accidents happen. Sometimes you slip in the parking lot, just like employees. Sometimes, sometimes you have injuries while walking to a client meeting. It is a no-fault system, as I stated. However, there are exceptions to the rule that unsafe workers get work comp benefits, and there's 4 safety rule violations, we collectively call them. They are safety rule violations you should know about, whether you're on the defense side or the claimant side. Number 1, a willful failure to follow a safety rule. I will tell you that safety rule needs to be publicized. It needs to be trained. The employee needs to be trained to it. The best way to do that is through an essay exam. It's not enough to just have a safety meeting, tell them the rule, and use the attendance sheet. I've been in the hearing room on safety rules a lot during the last 40 years, and I can tell you, unless we have a written rule that's clearly enforced across the board and the person is trained to it, we have no chance to get a safety rule violation. It's a 50% reduction of non-medical benefits if we get it. Rarely do we get it because the employer doesn't do those basic things of communicating it and training the person to it. The second safety rule is something called the willful failure to use a safety device provided by the employer. I used to represent a major insurance, like a ski resort in the state of Colorado, and they did provide helmets to their employees. And if you were injured not wearing one, you got a 50% reduction in your benefits, because as long as it's provided by the employer and you're not wearing it, and the doctor says your injuries would have been less if you had been wearing it, that judge is going to give you a safety rule violation of 50% of your non-medical benefits. The third safety rule violation is intoxication, we call it, and it includes alcohol, 0.10 or more blood alcohol level. There's a presumption that you were intoxicated by alcohol at the time of your injury. It is a rebuttable presumption, however. With respect to illegal drugs, it's also a 50% reduction in benefits if the employer can demonstrate that, in fact, the individual was under the influence of that controlled substance. The statute actually says the presence during working hours of controlled substance gives rise to a presumption the person was approximately caused by that intoxication. Now, think about marijuana. That is a controlled substance. It's a non-prescribed controlled substance and falls into that category. If a person has THC, however dormant, inactive metabolites in their system, they might have the insurance company argue they were intoxicated at the time of the injury. However, a good toxicologist or other set of facts, if you're on the claimant side, can rebut that presumption, and no safety rule violation will be awarded. The fourth safety rule violation, which is little known, and I think you employment attorneys need to know it, is this. If an injured worker or an applicant for a job before they're injured has represented that they can safely do the job, and they have lied about that because they know darn well they have a restriction. They know darn well they can't lift 50 pounds. They know that the last time they lifted 50 pounds, they were injured. If they go into the job and claim that they have no limitations, that there's no reason they can't do the job safely, and then upon reliance on that representation, the employer puts them on the job and they are injured, that employer and that insurance company can ask for a 50% reduction of their benefits. That's to discourage people from being dishonest with their potential employers, or upon returning from injury or leave, coming back to work after perhaps a no fitness for duty position, or perhaps the employer has asked them, can you do this job safely? Anything we need to know? And they say, nothing, you don't need to know anything. So be mindful, you defense attorneys, you should be advising your employers that they can, after extended absence where there's a legitimate question about whether someone can safely do the job, they can ask medical questions in a legal fitness for duty. That's the subject of a whole other seminar. And obviously, after a conditional job offer is made at the beginning of the employment process, before you put them on the job, you can ask whatever you want. And one of those questions should be, can you safely do this job? Do you have any restrictions? Have you had any injuries, et cetera, et cetera? You can do that between conditional job offer and putting them on the job. If that person lies to you and you don't find out about it until after they're injured, and they are injured approximately caused by that representation they made to you, I would go after that safety rule violation. The third thing you should know, that benefits in the work comp system are limited generally. Work comp system is not an early retirement system for most people. It's not particularly generous, and it's very difficult to get benefits sometimes. Having waged war against insurance companies for the last 12 years, I can assure you that even a seasoned attorney often has problems getting the proper amount of benefits for injured workers. People that aren't represented are getting railroaded and taken advantage of every day because they don't even know what benefits they should be getting oftentimes, and they don't know all the nuances involved. Here are those benefits that are potentially available to any injured worker, including yourself if you have your own work comp policy. First of all, medical benefits. Probably the 60% or more of the workers' compensation dollar is spent on medical benefits. Medical benefits are potentially for lifetime. There is no copayment. They have to be reasonably necessary and related. But under the Grover decision, one of the few workers' compensation cases that went to the Colorado Supreme Court, we know that potentially, theoretically, benefits are lifetime as long as they're reasonable, necessary, and related for maintenance purposes. However, it's tough sometimes to get those maintenance benefits paid for. And as a consequence, a lot of cases are settled where there is a waiver of future medical benefits, which is possible in the state of Colorado. Medical benefits include, obviously, surgeries, diagnostic modalities, bandages, medical mileage, and the whole like medical benefits, the whole range, prosthetic devices, et cetera, et cetera, et cetera. A second type of benefits called one of the indemnity benefits. It's called temporary total disability. It is a wage loss benefit. If somebody cannot do their job and they're losing time from work, after 24 hours, basically, and I'm oversimplifying it there, because there's a 3-day waiting period, often they can get temporary benefits. It's measured by 2/3 of their average weekly wage. Average weekly wage issues are fought all the time. It's always a question of what is the average weekly wage in a particular case. There is no statutory guidance exactly on what it is. It's really common sense and what's reasonable under the facts and circumstances of the case. Personally, I believe that a sample of 1 year prior to injury is probably the best sample, but there are other ways to get to the same place. Average weekly wage issues have to be resolved to be able to calculate temporary total disability, which will continue until the person's at maximum medical improvement, have been returned to work at the regular job, have returned to work, have missed a rescheduled doctor appointment, have not shown up for a job, transitional job offer that's been made properly, with emphasis on that. We'll talk about that in a few moments. Or if they pass away. So maximum medical improvement is the most common trigger for the end of temporary disability benefits without the need for a hearing. The carrier can just cut off benefits at that point. Temporary total disability also can lead to or is accompanied by temporary partial disability. When a person goes back to work part-time, whether it's for the same employer or another employer, or they go back at a reduced wage, they may be working the same hours but at reduced wage, they may be entitled to a benefit called temporary partial disability. That's measured by 2/3 of the difference between what they were making at the time of their injury and what they're making now. Temporary partial disability is an important benefit for people to help them get back to work and not suffer wage loss. Another benefit, this is in the category of permanent disability benefits, is called permanent partial disability. Permanent partial disability is measured actually by medical impairment. It's supposed to compensate people for the loss of their earning capacity in the future. But in our system, that concept of compensating people for anticipated wage loss is actually determined by reference to a medical impairment rating or ratings. It's a complicated process. A lot of battles are fought in this regard, but permanent partial disability is commonly awarded to those who are seriously injured in our Colorado system. In those cases where people are drastically injured and cannot return to the same employer or any other employer for that matter, there's a benefit called permanent total disability. Permanent total disability is also measured by the average, 2/3 of the average weekly wage, and it's paid lifetime, generally speaking. Difficult to prove permanent total disability in the state of Colorado because you have to prove a negative. And the negative is you can't work for anybody doing anything, light duty, temporary work, anything. You have to prove you can't do that. Now, that can be done with people who are drastically, seriously, chronically disabled. Those who are highly medicated, those who may be paraplegic or quadriplegic, those who have traumatic brain injuries, people that are older, people with other disabilities, including inability to actually hold a job in the United States because they don't have papers to do that, et cetera, or a combination of those factors can lead to permanent total disability. As I say, it can be lifetime if a person qualifies or if it's settled out on a permanent total disability basis. Another benefit is called bodily disfigurement. If you're scarred or have a limp or have some kind of a burns or some kind of bodily disfigurement that carries with you, you can be compensated for that. It's a two-tiered system. I won't say minor disfigurements, but those disfigurements which are considered by the judges to be not as great as major ones, there's a cap on what you can get for those kind of benefits. But if it's a serious disfigurement, amputations, scarring around the face, these sorts of things, there's a higher cap. It's not a whole lot of money. I think it's $13,000 the most you can get, but it is an additional benefit. By the way, medical mileage is a benefit you get under medical benefits. Some people ask or thinking, well, what about vocational rehabilitation? Is that a benefit in the state of Colorado? And the answer is, as of July 2nd, 1987 at 4:16 p.m., when the governor signed the bill, vocational rehabilitation as a mandatory benefit was ousted from our system. It's only offered occasionally. It's a voluntary benefit, usually only offered if there's a real threat of permanent total disability. Because an offer of vocational rehabilitation the person can reasonably do that is turned down can mean they cannot get permanent total disability benefits. There's one other benefit. It's called dependent benefits, or sometimes it's called death benefits. I don't see a lot of those cases. I haven't seen them a lot, fortunately, in my 40 years, but there is a whole system for compensating spouses and children and other relatives if they can qualify as partial dependents, and I'll leave it at that for now. That also includes funeral expenses up to a certain limit. Those are our benefits that are available. I call them limited because, quite frankly, and this is a personal opinion, those people who suffer extremity injuries, injuries to fingers, hands, toes, and feet, knees, these sorts of injuries often are, in my opinion, undercompensated. When you talk about back injuries or neck injuries or head injuries, we're talking about what's called whole person impairment, and those awards are based on age and wage, and those can be substantial awards. But when you're talking about scheduled injuries like fingers and toes and wrists and knees and these sorts of things, it's a pretty strict schedule. It's a three-factor formula, and people are not well compensated. They may have lost their careers, but they don't get very much money for it. We have an inequity in the system, in my opinion, that has never been remedied, despite the best efforts of the claimant's bar. And I probably will see that inequity through the rest of my career, and it's sad. It is for this very reason that these scheduled injuries are not highly compensated, that a lot of people are not well represented or represented at all in the state of Colorado because they can't find an attorney to take their case because there's no money in it for the attorney to take that case. And that's all I'm going to say about that at this time, as Forrest Gump used to say. We talked about safety rule violations. I'm going the wrong way. Compensability is not logical, predictable, intuitively obvious, or fair. when I meet with claimants for the first time, and they go, well, how does this work? And can I expect to get a fair deal? And I say, probably not, because the system is not inherently fair. It's not intuitively obvious. It's not always rational. It's not logical. It's not always predictable. It just is what it is. And anybody who wanders into the work comp system doing other practices and thinks they can do a work comp case in a matter of a week or two or even a year has another think coming, because there's a lot of nuances, not only in the statute, not only in the rules, but in the way things are practiced. So, kids, don't try this at home. If you have a work comp case, consult with a workers' compensation attorney, whether it's on the defense side or the claimant side. And I know Karen Burns, you're sitting there listening, ready to heckle me. She's a fine attorney and she's in your midst. Be sure to give her a call and say, how does this work, Karen, in the real world, especially here up in our Boulder community? If you do want to have a sense of how do you figure out whether a case is compensable or not, you start with, of course, Colorado Revised Statute Section 8 has the Workers' Compensation Act, and there are statutory rules which will tell you in some instances whether the case is compensable or not. There's statutory language about who's an independent contractor and who's not. Is a ski instructor covered? Is a volunteer covered? You can find that in the statute. But a lot of questions about whether somebody's covered for workers' compensation are doctrinal. They are found in workers' compensation case law doctrines. And one of the best ways to find out whether a parking lot injury is compensable or not, or whether traveling to and from work is compensable or not, or whether falling down at work is compensable or not, is again to go to the statute in the annotations, because there's a lot of case law examples there. But I would also recommend to you another great book. It's Phillips and Phillips, Colorado Workers' Compensation Practice and Procedure. As we learned at the University of Texas Law School 43 years ago, I've learned ever since, don't forget the pocket parts. Get the updates, because they are so important to understanding how the work comp system in the state of Colorado works. This book has helped me in writing briefs, to understand cases, to advise clients. I cannot pitch it enough. No, I don't get any commission for pitching it. I'm just telling you, if you want a one-stop shopping treatise on Colorado Workers' Compensation Practice and Procedure, and you've exhausted the Division of Workers' Compensation website, their guidances and their missives about workers' compensation, go to Phillips and Phillips or go to the statutory annotations. Don't try to figure it out on your own. For example, one of the most common injuries in the state of Colorado is somebody falling on the ice at work in the parking lot. Well, is that compensable? Well, it depends. There's a lawyer answer for you. Are they in an assigned parking space? Are they where most employees park? Can they be in that part of the parking lot? Were they on the most direct route from their car to the office or to the factory place where they normally work? Did they go off on an errand or a personal errand? Did they go off to 7-Eleven to get their big gulp? Were they practicing their Lord of the Dance moves in front of other people and showing off? Were they showing off the gun they just bought at the auction the other day? It depends on all the factors, and you got to know the law and the exceptions to understand all that. Kids, don't try this at home. My next point is that taking care of claimants is crucial. I gave a presentation about 25 years ago to a management group, and I was, of course, speaking for the defense side of things, and in attendance was Steve Mullins, the late Steve Mullins, who was a claimant attorney, officed in Colorado Springs. He practiced all up and down the Front Range, especially Pueblo and all over the state of Colorado. And what he said in front of that group, I never forgot, and I would share it with you today, no matter what side you're on. He said he polled people why they came to his office to retain him as an attorney. And he said the top 3 responses were as follows. Number 3, reverse order, give me a drum roll, please. Number 3, reason why people get claimant attorneys is because their checks are late or they're not getting them at all. And that made perfect sense to me. And that's why you, as a defense attorney, should get that employer to, the insurance company to do that investigation and make a decision and get some benefits to that claimant as soon as possible so they don't go out seeking an attorney. And you as a claimant attorney, you need to do everything you can to get to that claims adjuster the information they need to make a decision on compensability so they can get those checks going, because people, generally speaking, in my world, live from paycheck to paycheck. And when it ends, unless they got a sugar daddy or they've got a family member that can support them, welfare is limited, unemployment compensation tough to get sometimes. It's tough, and they freak out and they will go to an attorney. So you as an employer representative should tell your employer, what kind of loan system can you create over here at this place of employment to bridge the gap when a case is being investigated by the insurance company has not yet been admitted to and the benefits aren't yet coming? How do we keep this person afloat? Why don't we give them a loan that they can pay back under favorable terms so they don't have to go seek out an attorney? And by the way, why aren't we telling them what they need to do to get that insurance company the information they need, whether it's medical releases or names of doctors or give a statement, whatever it is, so we can move this thing along? More on that later on when I talk about investigation. The second reason that Steve Mullins said people seek out an attorney is because they want to change a doctor. Now, this was before we had a system where the employer is supposed to designate at least 4 medical providers, at least 2 of which are unrelated economically, before that system, but it's still true to this day. People are tired of the doctors and the way they're treated in these systems, and they want to change a doctor, or at least they want to vent about it. So that's why they seek out an attorney. And when they do, the attorney will ask them, are you getting medical mileage? And they say, what are you talking about? And when the insurance adjuster has not told them that they, in fact, could get 58 cents or whatever it is per mile for going back and forth to pharmacies or to doctor appointments or physical therapy appointments, the person feels had. They feel that they have been betrayed. They feel they're not getting the full story, and they will sign up with that claimant attorney. Steve Mullins told us that 25 years ago. It's still true to this day, I found, now being on the claimant side. But here's the number one reason why claimants get attorneys, according to Steve Mullins, who, for those of you who remember him, he was not necessarily a bleeding heart type of person. I wouldn't say the picture of a bleeding heart in Funke Wagnalls had a picture of Steve Mullins next to it. But here's what he said. No one from work called me up to ask me how I was doing. Did you hear that? Nobody at work reached out to them to ask how they were doing. And when people feel that they've been rejected by the employer, there's no offer of transitional duty, they don't know how the system works, there's nobody to cut through the red tape, there's nobody to be their ombudsperson, there's no one to take care of them, they will get an attorney. And so for those of you who want to improve the work comp system, you want to avoid the attorneys that you think are such the bane of your existence, well, why don't you tell your employers to reach out and take care of people and give them the information they need so they don't have to go to an attorney? And by the way, when you're talking to them, urge them to bring the person back to work in some kind of lighter duty job so they're not freaking out, so that person has an income stream, so that person can go home with their head held high and not have to tell the loved ones that, geez, I'm out of work, I don't know where the money's coming from, et cetera, et cetera. That's an impassioned plea. I can tell you, after 40 years, a lot of people are not listening to that very basic rule. You need to take care of your employees or they will go off to find attorneys. And remember what I said, 50 to 60 or maybe 70% of them won't find attorneys, and they will be taken advantage of by the claimant's bar. I guarantee you, it's like that. They will be taken advantage by the insurance companies because there aren't enough claimants bar to take care of them because there's no financial incentive to do that. And for God's sakes, a lot of claimants, attorneys do give pro bono advice. They try to help people to navigate through the system, but they cannot run their businesses by taking on finger cases or toe cases or whatnot, because that could be as big a battle as a traumatic brain injury sometimes. And you just can't economically take those cases, unfortunately. Prompt investigation is important. I would go so far to say I would go as far as to say that investigation is part of a good faith practice when adjusting a claim. You got to get in there and investigate as soon as possible. If you're on the defense side, you as the employer got to help that employer find out, is there a surveillance videotape? Was that taped with that injury? What information do you need from us, Mr. or Ms. Adjuster, to get this case admitted? What statements can we provide you? What information can we give you? What personnel files can we give you as soon as possible so that you can find out what's going on in terms of the person's wages and the conditions of employment? We need to cooperate with that claims adjuster, but it starts with the investigation of that case. And it is not acceptable to continue to investigate a case over weeks or months. But it happens all the time, and I'll tell you why. And here's a tip to both claimant attorneys and to defense attorneys in this virtual room, and it's this. While there is a duty to investigate and do so promptly and completely, and it's bad faith, in my opinion, not to do that, all the adjuster has to do is send that injured worker a release for them to sign and a request that they complete a list of doctors they have seen for the last 5 or 10 years. The uninitiated in the system is fearful of that. They can't get advice sometimes about what they should do with that. They sit on it. They don't open their mail. They don't do anything with it. They don't provide the adjuster with that information. And that's all the adjuster has to record in their notes, is they ask for the information so they could properly investigate it, or sometimes give a statement they'll ask for, and the person doesn't get around to doing it. That's all the excuse the claims adjuster has to say, well, I tried to investigate, I couldn't, we're going to continue the denial of this case. So no matter what side you're on, help that claimant get that information to the adjuster so it can be properly investigated. Let's see. Great doctors are key to rapid recovery. Goes without saying that when somebody's injured, they're scared, they're depressed, they're anxious. Is this going to ruin me for the rest of my life? Am I ever going to be the same? Well, it's incumbent upon the doctors who service those in the work comp system to be not only competent, but also be compassionate and to engender hope. In graduate school, so many years ago, I did a study of a number of psychological and physical models for rehabilitation. Everything from EST, some of you may remember EST, and transcendental meditation, Jungian theory, Freudian theory. I looked at all those. I did a comprehensive study of all those psychological and physical philosophies or modalities for bringing people back to health, mental and physical. And all I could tell you that I found, which the common thread, is this. The ones that lasted, the ones that were highly rated, the ones that were effective in returning people to a state of mental or physical health were those that engendered hope. H-O-P-E. You got to give people hope, or your quest to get them better is not going to work so well. They're going to be disenfranchised. They're going to feel hopeless. They're going to seek out attorneys. They're not going to get better. They're going to be anxious, depressed, et cetera, et cetera. So whoever the doctors are that are treating, they ought to be darn good. And they ought to engender hope. And they should not engender expectations which are not necessarily realistic. And I'll save my pitch on setting expectations to my last bullet point, number 12. But as a preview, I will tell you, unfortunately, in our system, the doctors are not communicating realistic, fair expectations to clients. And therefore, we have a lot of more litigation and unhappy claimants that we should have. More on that coming up. By the way, with respect to doctors, as I said earlier, it's a requirement that employers or their carriers offer a list of 4 doctors. This is in the major cities and so on. Rural areas, it's a different rule. But generally speaking, in the Denver, Boulder, Front Range communities, you have to offer a list of 4 medical providers, 2 of which are economically unrelated, and the claimant can select one of those. It's not good enough for an employer to say, you're to go to Concentra, or you're to go to urgent care, or you're to go to emergent care, and that's it. No, you have to give them a list of four, and you should give it to them in writing. You should train them to that. You should have it posted. You should let them know they have a choice of medical providers. You should also let them know that if they're unhappy with their medical provider because maybe they're not engendering hope, maybe they're not compassionate, maybe they don't know what they're doing, maybe they're not making the right referrals, maybe they have cold, icy hands. Who knows? Whatever the reason is, if you want to change a doctor, you can have one automatically as long as you get it before your maximum medical improvement. I think it's within 12 weeks or so. There's a rule on that. Karen Burns knows it better than I do. But in the first instance, the claimant can automatically shift, and the insurance company can't stop them from doing so to one of the other medical providers on the list. Too many insurance adjusters don't tell injured workers about that right. Too many employers don't tell them about it. Too many attorneys don't know about that. And as a result, the right to switch doctors, which empowers the claimant to get maybe a better doctor, is lost. So don't forget that. Cooperation with claims management is so crucial, whether you're on the defense or the claimant side. When it comes to the claimant attorney helping the claimant, you want to get on the line either by email, fax, or better yet, on the telephone and talk to that claims adjuster and ask, what do you need to investigate this case? What do you need to get to a decision on compensability in this case? Talk it out with them. So many times you'll hear from the claims adjuster, well, I don't have the release, or I want to take a statement, or I don't have a list of medical providers, or there's an allegation the person did this while engaged in karate activities or something like that. And the claimant attorney can do whatever they need to do to help satisfy the claims adjuster that no, this is a legitimate injury. We'll get you what you need to make your decision. Because you have to remember, all of us, that in the insurance world, there are 4 to 6 or more layers above that line adjuster who are looking over that work of that adjuster, who are looking over the decision making that adjuster. And that adjuster's job is on the line unless they fully document every decision they make to award or deny benefits to a person. It's so much easier for that claims adjuster to deny the case because then who's gonna take fault with them? Barring a bad faith allegation, who's going to take fault with, well, we denied it pending investigation. But to admit on a case, that adjuster's got to have their ducks in a row. They've got to have it well documented. And if they don't have what they need, they're not going to do it. We've got to, on the claimant side, help them do it. By the way, I'm fully claimant now as of September 16th of 2022. I've now been a year where I'm exclusively doing claimants work. Cooperation with claims management is also important if you're on the defense attorney side, because again, and I am charging you with a duty to help that claims manager, that claims adjuster, whatever you want to call that person, get that case investigated early and make a decision early and tell the claimant, and hence the potential claimant attorney or the actual claimant attorney, why the case is being denied so they can figure out what they need to do. Sometimes claims get filed against the wrong insurance company. Well, it's helpful if the claims adjuster tells you we didn't have insurance coverage during that time. Well, it's helpful if the insurance adjuster tells you we need that list of medical providers so we can go get your records and satisfy ourselves that you didn't already have a pre-existing knee injury or back injury or head injury or whatever. So help that claims adjuster by helping get that information from the claimant, getting it from the employer representative about what they have in their confidential medical file, what they have in terms of incident reports that have been filed, what they have in terms of surveillance or photos or workup and that sort of thing to get that case investigated, admitted. And Karen is now posting, it's 90 days. You have 90 days during which you can have an automatic change of doctor, and that is automatic. And the insurance adjuster can't say no, you can't do that. It's going to happen. If you miss that 90-day window, and you want to change a doctor, you have to write to the carrier and ask for a change of that doctor. And typically, carriers will say no. At which point, you, the claimant attorney, will negotiate with them and say it's in your best interest to have a doctor here who's treating somebody who knows what they're doing, that the claimant can trust, to get them to maximum medical improvement as soon as possible. That's what the good defense attorneys will do with the claimant attorneys, is talk it over with them about what doctor can we get, and not put their foot down and say, they missed the 90-day window, they're not going to get a change of doctor, you'll have to take us to hearing. Because I will tell you, and Karen Burns probably can verify this, if the claimant makes a persuasive case that treating doctor is not looking out for their best interests, who is not competent, cannot be trusted, most judges will award a new doctor in that case. So you're better served, if you're on the defense side, to get your employer or your insurance company to negotiate a better doctor. Return to work programs are vital. Why? Because again, it harkens back to what I said, is that people, when they don't have a paycheck, start freaking out, and they will start getting anxious, depressed, frustrated, and they will seek out attorneys. Many times, which they won't get, but they'll still be anxious and frustrated, depressed. And it will lengthen the time it takes to get them to maximum medical improvement. A more humane approach is to get person back to work as soon as possible. I will laud Pinnacle Assurance for a lot of things, and one of them is they have a very, very sophisticated and dedicated return to work program, and they will train employers about how to think outside of the box, about what kind of duties that employer can put together to have meaningful duties, not counting paper clips, meaningful duties to bring that person back to work at their same wages, or if it has to be lesser wages, at least some wages, so that that worker is getting up every day, shaving or whatever they're doing to get to work, get ready for work, go to work, and going to work as part of their peer group. They can say they are working. There is no blip in their employment screen. It's just so much better if we get people back to transitional duty work. I can't say enough good things about it. It's good for the insurance company. It's good for the injured worker. It's good for claimants' attorneys. We have a lot easier time of it when someone's back to work. We can be more relaxed about resolving issues when someone's back to work. So I can't say enough about doing those things to get people back to work as soon as possible. There are a lot of forms. In the chapter that Kyle is going to send you, entitled Workers' Compensation and Seniors, you're going to find a section 10-4, which is a description of basic forms in the workers' compensation system. I've distilled down to a list of 10 or 15 forms that we commonly use and how we use them. Take a look at that. You can also go online at the Division of Workers' Compensation website. They have a very user-friendly website. It has a listing of forms. The forms themselves often have instructions about how to complete them, when to complete them, and why to complete them. We do have, I will say, the Division of Workers' Compensation, while it has to remain neutral, it does a pretty good job of educating stakeholders in the system about how the system works. But remember, they have to remain neutral, and they're not going to take sides against the insurance company when push comes to shove, any more than they take sides against the injured worker. I won't bore you with all those forms. Suffice it to say, there's a lot of forms in the workers' compensation system, but if you think it's a form-driven system, think again, the forms are just the beginning. There's so many rules, statutes, cases, and unwritten rules about how you comport yourself that reliance on forms alone is not going to tell you the story. Hearings can be stressful. For those of you who are trial attorneys, you know what I'm talking about. I have to tell you, in law school, I avoided all the trial tactics and appellate courses that I could. I said, I'm not going to become a trial attorney and wind up a drunk with multiple marriages. I can't stand the stress of this. And what have I done? I went into workers' compensation. And I will tell you, trials are fairly short in the workers' compensation system. We call them hearings. There's a lot of good rules that allow us to get evidence in without authentication. Medical records, vocational records, employment records, generally speaking, if well produced, 20 days before hearing, go in automatically. That's wonderful, so you don't have to haul in a lot of people to authenticate your documents. So that's less stressful right there. But in the hearing room, we do give opening statements, and we do put on witnesses, and we do cross-examine, and we do all the things that trial attorneys do. We just do it in a more compressed time usually. We still write those briefs. We still make those motions sometimes in limine, sometimes during the course of the hearing, sometimes post-hearing. I have under my belt over 750 hearings. So I've been in that hearing room back when it was in person, and now that it's virtual, and now it's going back in person in some venues. I don't mind hearings, and they are not as stressful for me as they are for other people. I am a trial attorney. Our business model at our firm is we will try cases, and the insurance industry knows that. They know we will go to hearing. We'll do those depositions, we'll do those pre-hearings, and we will go to hearings, and we will write those proposed orders, even though it takes 8 to 12 hours to do it, because that person needs their day in court, and they need to have someone stand up for them. But I will tell you, hearings are stressful for witnesses on either side, and preparation of those witnesses is so crucial to put their fears to rest, about tell them how to act and how to not act, what to wear, and how it's all going to work. That is so important. And I can't say enough about that, but I will stop there. And finally, I will say attitude is important. And what I want to focus on now is setting expectations. And you can put this in the category of he's pontificating now, and that's okay, because, you know, when you've done 40 years of this and you've seen the way system works, sometimes you're entitled to speak your mind about how things work and how it should be better. And if I was the president of everything and could change the work comp system, one of the first things I would do is to tell doctors to knock it off with telling people the following, because this is what happens at a lot of doc in the box shops. A lot of the occupational specialists go, well, here's how it's going to work. You're going to come and see me every 2 or 3 weeks. I'm going to make referrals for physical therapy, and you might have a CAT scan or an MRI, and then you're going to come back and we're going to talk about that. And we might make a surgical referral. You're going to come back and talk about that. And you're going to do this and you're going to do that, and you're going to come back and see me over and over again. It's called churning, ladies and gentlemen. But eventually you're going to reach a state called maximum medical improvement. That's when you are as medically stable as we can get you. And at that time, we're going to give you some measurements, and you're going to get a permanent disability award based on those measurements. But what's wrong with that picture, ladies and gentlemen? That sets expectations from the start that the person is going to get a monetary payoff at the end of this road they're engaged in. And that as long as they play the game and go to those appointments, go to all those referrals, and act like they are disabled, and at the end of that road, they're going to get compensated. Everything I've seen and everything I've experienced and all the smart doctors I've talked to say the same thing. What you ought to do from the outset of a work comp case is give them hope and tell them, you know what? You've had a back injury here, but chances are within 6 to 12 weeks, you're going to be fine. You might need physical therapy to teach you home exercises, but you can do them at home, and you don't need to go through 12 or 20 physical therapy exercises. You might not even need to do one physical therapy. You don't need a CAT scan or MRI at this point. Why don't you go do these things and let time and your exercises and good nutrition and the love of your family and your work group sustain you so you can get better, instead of delivering a message, well, at the end of this road, you're going to get paid if you just play the game. Now, I know that's counter to my economic interest and my firm's economic interest to say that, but I think it's very, very sad that people are conditioned to believe that for sure they're going to have a physical or a mental impairment at the end of that treatment road. So I think doctors need to set expectations better and differently. And again, let me underscore, the smart doctors I talk to are the doctors that tell people, you know what? You're probably not an outlier. You're probably somebody that's going to get better day by day by day if you just follow these simple rules and so on. Don't act like this is the end of your life, because it's not. Now, if you're still presenting with problems 3-6 weeks from now, come on back. We'll talk about it, what needs to be done next. But I'm giving you hope that you're going to be back. You're going to be recovering right away and back to work and back being a productive citizen as soon as possible. From the claimant attorney's perspective, setting expectations is so important too. A lot of people that come into the system think that workers' compensation is easy, that the claimant attorneys with a phone call can make things happen, that they're going to get a lot of money if they play the game. We make a point to tell claimants it's not going to be an easy road. It's not going to be easy to get adjusters to do anything, that we're going to have to walk you through and guide you through a lot of what seems like unnecessary paperwork and investigation and invasion of your privacy, et cetera, et cetera. And at the end of the day, this case may result in settlement because you may not have the financial resources to take on the insurance industry, which has unlimited resources to send out the surveillance teams, to hire the doctors who will say whatever they pay them to say, et cetera, et cetera. So we try to set expectations clearly from the start so that when it gets to the settlement table, or when it gets to the eve of hearing, or maybe post-hearing when they get a negative result, there are no surprises. So setting expectations is important for the claimant's attorney as well. On the defense attorney's side, setting expectations with your client, if you're representing the employer, that they have a role in this, that they need to cooperate, and that they should embrace the claimant and take care of them, helps that employer do what most employers don't do. And here it is. And I tell people this story from watching Animal Planet. A lot of you do watch Animal Planet. You've probably seen Animal Planet when we're on the plains of Serengeti, where the gazelles are migrating from one place to another. And one of those gazelles steps in an anthole and breaks its leg. Well, the fellow gazelles surrounding it look at it, try to nudge it to move it along, but it can't walk. They don't stick around, do they? They get the hell out of there because they know what's coming. Yeah, Darwinism says that lion or pack of lions or hyenas or whatever is coming, and that's going to be fair game for them. Well, I think it's primal, and I've found in my experience over 40 years that employers, when they are confronted with an injured worker, don't embrace them. They go the opposite direction. They reject them. They want to expel them from the system. They want to get them out. And that's why they don't tell them how it works. They don't cut through the red tape. They don't give them hope. They let the adjusters give them hope. They let the attorneys give them hope. They don't do it. I'm going to suggest to you that you have a duty to tell your client, whoever it is, that they need to do those things to embrace that claimant, to cooperate with that claimant, so that they don't feel that they're going to be left behind and the lions are going to come in. That's my final message to you in this presentation. I have 5 minutes. You can unmute yourself if you have questions or comments. And Karen, come on in if you want to comment on what I've said. You've got 5 minutes to do it.
Hi there. I have a
Hi,
question.
Greg. I would only add that on average weekly wage, mention concurrent employment.
Yeah, great point. Concurrent employment for everybody. When somebody is, at the time they're injured, if they have a contract of hire where they're working for more than one employer, that wage that they're losing, if they're in fact losing it, should be included in the calculation of the average weekly wage. And Karen, thanks for making that point. It's so important because so many benefits are contingent on the correct average weekly wage. You want to be sure you ask your client, were you working doing something else? Did you have an expectation that you'd be working? Because the contract of hire is what's important. But if there's a firm expectation that, hey, I'm going to have a summer job and now I can't do that, that might be included in the average weekly wage because, as Karen knows, and those who are practitioners, judges have broad discretion to fashion a wage which is fair under the circumstances and facts of the case. There was another question. Brooke, what's your question?
Hi, thanks. My question is around any requirements, statutory or regulatory, for how long employers need to keep an employee employed when there is a workers' comp situation. Because I have seen cases where we've had employees out for 12, 15, 18 months with no real knowledge if they're ever going to be able to come back to the job, and whether there's a point at which, you know, an employer can terminate that employee and not run afoul of any of the statute or regulations.
Brooke, that's a great question. I'll answer it this way. No, in the Work Comp Act itself, unlike some states, there is no requirement to keep someone working. There's opportunities to offer them transitional duty, and there's consequences when they don't come back, but there is no requirement to keep someone working. And as you well know, it's an employee at will state. So the handrails for keeping someone working, of course, are the ADA, FMLA, and Title VII and all those kinds of rules. I don't pretend to be a full-time employment lawyer, but I know enough to be dangerous. What I do when I am confronted with a situation where somebody is fearful they're going to lose their job, I encourage them to apply for Family and Medical Leave Act if they're entitled to it. ADA asks for a reasonable accommodation meeting, and as necessary, I will send them to a full-time employment attorney for a consult, to pay a couple $100, $350, whatever dollars to consult with them about what their options are. I will tell you my experience, and I bet Karen will agree, is most employers are savvy enough to keep someone working until they're at maximum medical improvement, because it's at that point permanent restrictions are assigned. And it's at that point the employer has now data which they can base their decision whether they can terminate the person because there's no match between the person's restrictions and the essential duties of the job. I hope that I answered your question. That's really the subject of a full seminar. And I will also add this, and again, you can put this in, I'm pontificating now. I'm cathartic. I'm complaining. I'm griping. Too many claimant attorneys go along with what the insurance companies require, which is a resignation in order to settle the case. In my opinion, and it's a strong one, is if it's not a self-insured employer, that insurance company doesn't have a dog in that fight. They don't have a right to require that the person leave their livelihood, quit their job as a condition to settle that case. Now, if it's a self-insured employer, I think it's a different story. I think that's, since there's no duty to settle, a self-insured employer could say, I'm not going to settle with you unless you resign and give up full employment rights. But I think insurance companies have no business on this earth requiring people to terminate. Yet, a lot of claimant attorneys, to get that case settled, will convince the claimant, yeah, you don't want to go back there anyway. They're ostracizing you. You hated them. They're not going to take good care of you. They're going to get rid of you sooner or later. We convince them to go ahead and resign because it's a lot easier for us. And I would charge us to double think that and say, you got no business requiring this person to give up their livelihood when the case is appropriate. Thank you, Brooke, for that question. I think we're at the 1 o'clock time. Is there one final question or comment? Hearing none, ladies and gentlemen, thank you for your kind attention. I know some of you were multi-tracking. Thank you. Thank you. Thank you, Boulder Bar, for inviting, County Bar, for doing this, and you employment attorneys. I hope that you can go out there and you can help adjust these claims with a good head as well as a good heart. Thanks so much. Take care. Kyle?
Thank you again, Greg, and thank you all for joining us today. Like I said, I will send out the PowerPoint, and Greg had sent over a chapter from Colorado law he'd like everyone to review to kind of add some texture to context to his presentation. So if you need anything further, please contact me or Veronica, and we can make sure your questions or comments make it to Greg. There's a lot of thank you, Greg, in the comments. So thank you again, Greg. It was a great presentation.
Thanks, Veronica, for putting this together. She worked hard. She gets applause for that, too. Thank you all. Take care.
Thank you.
Bye, everyone. We'll be in touch with further employment law section events as soon as possible. Watch the e-brief and the Wednesday upcoming events. Thank you again and have a great day.